Bill Limit 4426 says, "Greetings." Bill Limit 4426 says, "Greetings."
Greetings and welcome to Pleading, Expression and Wording from American Jurisprudence. I hope everyone got the notification. I didn't get it this time, but it seems like more people that did than I did, so that's a good sign. That said, before we get started, just to remind everyone, this is strictly for the entertainment educational purposes of this YouTube channel broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise. So whatever you do, just please don't do this at home. That said, let's get started. And if you haven't already, please do hit the like. Where did it go? And I believe we have the text-to-speech running here, so if you put a comment.
The tribe says, "Hit the like."
Indeed, it'll read it back for us all. So that said, let's get started. So we're on to the expression and wording involving pleading, and this is from the American Jurisprudence.
Shadow Hippie 1776 says, "Hit the like button, people."
Thank you, indeed, and thank you for joining a membership with the Tribe channel. And let's get started here. So now this presentation here actually is going to be extremely comprehensive regarding pleadings, and if you followed the last ones we did on this, it'll really give you a rounded understanding, almost like being in a quasi-law school. But let's get started. Modern pleading practice has evolved from the rigid technicalities of common law to a system that prioritizes clarity, substance, and efficiency. So these are key words to think about when making any kind of a pleading: clarity, substance, and efficiency. The presentation will guide you through the essential principles of expression and wording in legal pleadings, as outlined in American jurisprudence. We'll explore the standards for clear language, the requirements for brevity, the proper structure of captions and paragraphs, and the critical importance of avoiding sham or frivolous claims. As you see here, I won't necessarily read all these, but you can see how we have it grouped here with foundational principles, with a manner, and of course some federal practice included. The caption, pleading integrity, go over the sham and frivolous pleadings and how you identify those. Language and brevity, where we go over the wording, and the structure and form, where we'll have some paragraphs, how they should be structured within the pleadings, and we'll have a special bonus with the federal forms, which has been taken out from the standard federal rules of civil procedure. It used to be in an appendix, and I was able to find an archive version, and we have that as a special extra after the presentation. Let's get started so we can get to that. Trick or treat. So, section 31 is where we left off last time, and now we're on to the manner of pleading facts. Modern pleading practice. In contrast to the technicalities of forms of pleading which prevailed in the common law, modern pleading practice only requires a pleader to state the facts constituting the cause of action or defense in clear, ordinary, and concise language, and with certainty and definiteness. So you want to be definite and certain in the claims made. Clear, ordinary, without too much excessive terminology, and concise language, or I should say jargon, really, but concise language, which may involve some terminology. Neither inferences nor conclusions should be pleaded, nor should the evidence with which the pleader intends to establish his or her claim or defense be pleaded. So we're not pleading conclusions, inferences, or evidence, just facts. Facts may become evidence through the deliberations. However, at the pleading stage, stick to facts. Although pleadings are required to be simple, direct, and concise, they must contain such statements of facts as may be necessary to show the pleader's entitlement to relief. So you got to show that there is a relief that the pleader is entitled to. That's one of the essential elements here of the pleadings. The practice tip here: no particular form of words is required because it is the substance of a pleading, not the form, that is paramount in present practice. So this is a very key element right here, is the fact that the substance, not the form, is paramount practice. So there's no standard form, so to speak, for making pleadings. However, there are some basic requirements for that. Give me 1 second here. For some reason, I can't pull up the chat, but we'll get that going in just a moment. Oh, I see what's up here. Okay, 1 second more. We'll edit this out. Okie doke. All right, now we're back online here. Okay, so the observation here is, although a pro se pleading is held to less stringent standards than one prepared by an attorney, it must comply still with the basic pleading requirements, which we're going over here. Things like ordinary, clear, and concise language. These are things that even a pro se must be able to include within a pleading. These are the requirements, and they make sense. Again, even things like staying away from inferences and conclusions in a pro se pleading is something that, even though it's less stringent standards, it doesn't benefit the pleading. So by complying with the basic pleading requirements, it also elevates it to a higher level than just a pro se. And of course, you don't want to be rated on just entitlements or affordances. You want to have it based on the things that are essential, the substance of the pleading. Let's move along. Federal Rules of Procedure. The Federal Rules of Civil Procedure provide that the allegations of a pleading shall be, so this is input, that it shall be simple, concise, and direct. And no technical forms of pleadings or motions are required. These pleadings requirements apply only to affirmative claims and to responses to claims and counterclaims. So our observation here, the purpose of the rule is to eliminate prolixity in pleading, to achieve brevity, clarity, and simplicity. That even rhymes. So prolix is unnecessary extra wordage and verbiage and such. So by eliminating all that in a pleading is the way to achieve the brevity, clarity, and simplicity. So again, it's almost like distilling it down to the essence of what is necessary to keep it simple, concise, and direct, focused on substance, and of course the entitlement to the claim. All right, let's proceed on from there. A pleading, let's see here, claims subject to a heightened pleading standard are not accepted, not accepted, but accepted from the general pleading requirements of simplicity, directness, and clarity. So no one is accepted, even if it's a heightened pleading standard, something with maybe a very technical matters to it behind it that establish the claims, that even those kinds of claims are not accepted from the general requirements of simplicity, directness, and clarity. So that means there might be a lot of explaining to do within the claim. A pleading containing prolix evidentiary averments, which are largely irrelevant or of slight relevance, rather than clear and concise averments stating which defendants are liable to the plaintiffs for which wrongs based on the evidence, defeats one of the purposes of the heightened pleading standard, namely to avoid unnecessary discovery. So that's the heightened standard there. But as we see here, prolix evidentiary averments, right, are largely irrelevant or slightly irrelevant. I love how this is a very long sentence here. Rather than the clear and concise averments stating which defendants are liable to the plaintiffs for which wrongs based on the practice, defeats one of the purposes of the heightened pleading standard, namely to avoid unnecessary discovery. So, by containing prolix evidentiary averments, it may invite unnecessary discovery. So it could be harmful, as well as just breaking the rule of simplicity, brevity, and clarity. So again, prolix evidentiary averments, making unnecessarily verbiage involving evidentiary and, of course, averments or statements to be taken as facts or truth. So again, that's something that defeats one of the purposes of the heightened pleading standard. And again, which none are exempt from the general pleading standards. Let's proceed. Whew. This is not too long a presentation, but it is quite dense. And please stay to the end so you can see the special treat we have of the lost appendix of federal forms. Pleading caption requirements. Here's the caption and the designation of paper. So we all are familiar with the captions on the top of all the pleadings. So a pleading should bear a caption reciting the name of the court and county, and sometimes the city, in which the action is brought, the term, the number of case of the docket or calendar, the names of the parties to the action, and designating its nature. So we have here a nice little list of the pleading caption requirements: the court name, county, city, if that's applicable, the case number, and then the party names. Someone versus that. And of course the document type. So you'll have what title is, right? The parties to the suit should be named by their full and correct names, although the interest in the action or proceeding required to bring it is not created merely by including the name of a person or entity in the caption. So again, the caption is really just there for reference, mostly. Observation. Regardless of the designation given to a pleading by its author, the courts will disregard it and look to the body of the pleading to determine its true character. So again, the names, rose is a rose, whatever you call it. So the court will disregard it, whatever you call it, and look to the body of the pleading to determine its true character. Federal caption requirements. So in the federal practice, Federal Rules of Civil Procedure provide that every pleading must have a caption with the court's name, a title, a file number, and a Rule 7a designation. So here are federal caption requirements from Rule 7a. Court name, the title, file number, and a Rule 7a designation. Practice tip: the requirements of the rule for the caption of a complaint applies to amended complaints which add additional parties. So the requirements of this rule for the caption of a complaint applies even to amended complaints adding the names of additional parties. Key thing here if it's a federal case. Although the rule requires a pleading to be appropriately captioned, a defective caption does not deprive the court of its power to look beyond the caption in order to determine jurisdiction. The failure to comply with such a technical rule of pleading is not fatal in the view of the board principles underlying notice pleading under federal rules. Here's an example, good one here. A handwritten letter from the defendant was deemed an answer, although it was not in the proper form and lacked the name of the court. when it contained the title of the action, the file number, and a designation as an answer letter. And when the defendant mailed it to the court, it was filed and docketed as his answer, and a copy was mailed to opposing counsel. Handwritten. There it is. All right, now we're on to the fun stuff, the sham and frivolous pleadings. The sham pleading. Let's check over here at the chat, make sure it's still active. Everyone's still there. Please hit the like if you just joined. Although I didn't get a notification today, so I'm sure the notification's worth in. Salute to you all for being here. Let's proceed. A pleading is a sham when, although appearing in the usual form of a pleading, it contains false allegations, which may or may not be pleaded in bad faith. Indeed, the words false and sham are synonymous. Interesting there. So here's our observation. For purpose of a motion to strike a pleading, a sham pleading is one that is palpably or inherently false, and from the plain or conceded facts in the case, must have been known to the party interposing it to be untrue. So there we go. You just know it's false, and they did it anyways. And they're knowing it's untrue. It is not a sham if the allegations are true, though. So the allegations are inherently false or plain conceded facts. But if their allegations are actually true or are false but are not pleaded in bad faith, it's not a sham. So it's a bad faith pleading. Only after holding an evidentiary hearing may the trial court strike a pleading as sham. Wow, so it goes all the way to evidentiary hearing before it may strike a pleading as a sham if it finds that the falsity of the pleading clearly and indisputably appears. So then we get to the frivolous pleadings. Here's an example. A complaint filed by informa pauperis plaintiffs, so these are the ones that are getting it for free instead of paying the fee, was properly dismissed as frivolous since the allegations made in the complaint lacked an arguable basis in fact, as they were both fantastic and delusional. I guess you get your money's worth on that one. A frivolous, fantastic and delusional. So this is a great term to use here. A frivolous pleading is one which does not, by any view of the facts, present a valid cause of action or defense. A frivolous answer, since it does not present a legally sufficient defense to the claim or cause of action, is presumed to have been interposed solely for the purpose of delay. Wow. When a party claims his or her opponent has commenced and continued a frivolous action, he or she must overcome the presumption that the action is not frivolous. So what you accuse, they must overcome the presumption that it's not. So there's a high bar to do when you start calling someone frivolous. You have to then overcome the presumption that the action is not. Let's proceed. And continuing with the sham and frivolous pleadings. Court authority, both sham and frivolous pleadings. I see what's wrong here. There we go. Stricken by the court or disregarded without entry of an order striking them. Similarly, a general denial cannot be stricken unless it is a denial of matters of record, of written instruments to which the defendant is a party, or of knowledge of matters of which he or she might have informed himself or herself by reasonable diligence. So, a denial cannot be stricken unless it's a denial of matters of records, written instruments to which the defendant is party, or knowledge of matters in which he or she might inform, by due diligence. Sham pleading doctrine. Under the sham pleading doctrine, plaintiffs are precluded from amending complaints to omit harmful allegations without explanations from previous complaints to avoid attacks raised in demurs or motions for summary judgment. Wow, that's an interesting one there, the sham pleading doctrine. So plaintiffs are precluded from amending a complaint. So if the complaint contains things considered sham, some false statements are known to be false or done in bad faith, they're precluded from amending them to omit those allegations without explanation if there's previous complaints that are to raise demurs or motions for those false statements. That means that someone made put a complaint in or a pleading that had harmful allegations, then they amended it to omit them, but that wasn't before the other party complained about it. And they cannot amend that complaint without first giving an explanation why they're amending it to make sure it's not to conceal, I would assume. So we come to our practice tip. Many jurisdictions have enacted statutes or have adopted procedural rules empowering a court in a civil suit to order a party who has made a false allegation or denial without good reason or not in good faith to pay the costs and fees connected with providing the matter falsely alleged or denied. That's a good practice tip there. And a supplemental case. A complaint containing, as it does, both factual allegations and legal conclusions is frivolous where it lacks an arguable basis in either law or in fact. So it has neither, of course. That's in Ray Farnese from Pennsylvania, 2011. All right, so again, this is from a 2012 supplement of American Jurisprudence. So although it is quite dated, there's not too many new cases that are in it, but I do have the ones from that 2012 era in here. There may be some more. We'll see as time goes on in the newer editions, but this is what we're working with today. And for good reason, because before 2015, they had removed this secret appendix of federal forms from the Federal Rules of Civil Procedure, and this one references it. So it would be interesting to see how now that that's been removed and where that reference applies. And as we look through the forms too, we'll see what we're missing out on, but we could still use these forms if wanted. But again, there is no standard form, and maybe that's why they removed them from the public record. Nonetheless, let's move along here. Oops, what did I do here? All right, yep, we got all this done here. Let's move along. We're done with our shams and frivolous pleading. Now we're on to the next section here under wording. So here's generally on wording. First is the grammar and style. Incorrect grammar usage or other style faults are not important in a pleading unless they make it impossible for the court to determine what the pleading intends to present. So it has to have some semblance of grammar and style. Abbreviations and figures. Customary abbreviations and figures may be used as long as they do not obscure the allegation in which they appear. If the words and figures are used, however, in the event they contradict each other, the words control. So if you have an abbreviation for something and it's you give words for something else for that abbreviation, the words will control. You can't say that UCC stood for something other than the Uniform Commercial Code if you refer to it as that somewhere else. Of course, there's positive language. The allegations of a pleading must be expressed in positive language. They should not be expressed in such a way that they must be deduced by argument or inference from the attached exhibits. However, this does not mean that inferences or conclusions may not be utilized to supply a fact, which necessarily follows from those alleged. So in a chain of facts here, I can see that. But the positive language is kind of the guideline here for the general wording. Let's move along. Pleading should be as brief and concise as is consistent with the presentations of the issues, and not be unnecessarily repetitious or prolix. Several jurisdictions have statutes codifying these requirements. And our observation, the brevity requirement does not impair the requirement that the allegations be presented with reasonable clarity and definiteness. So the observation here is explaining that the brevity does not impair extra words used to clarify and define, but not for it must be remain brief and concise by avoiding unnecessarily in repetitious or prolix text. That said, this slide is brief as well, so a good example. Let's move along. Federal practice here. The federal rules requirements under the federal rules of civil procedure. Each averment of a pleading must be simple, concise, and direct. Ooh, we get that theme over and over. This rule, which complements the requirement of a short and plain statement of a claim, is intended to prevent parties from trying their lawsuit in the pleadings. So, another interesting distinction here, to keep the facts in the pleadings, not the conclusions. They're part of the whole lawsuit. Practice tip: despite the requirements of simplicity and conciseness, unsupported conclusory statements are insufficient to state a claim. And then we have court discretion over here. Granting a motion to strike a complaint on the ground that it was neither short nor plain was within the court's discretion when the complaint contained 119 pages and 367 numbered paragraphs. But granting a motion to strike a complaint on the ground that it was neither short nor plain was within the court's jurisdiction because it contained that many pages. So that's not short nor plain. The district court did not dismiss a case, but gave the plaintiff 21 days to amend the complaint. So I guess out of that 119 pages, he had to really narrow it down. But 367 numbered paragraphs. Can you imagine that? I guess that court was within the district court's discretion, it seems. That seems pretty long. Nonetheless, I'm sure it contained prolix. That'd be an interesting one to look over, but not on this one. All right, Section 38, Federal Practice with the prolix complaints. A complaint which is prolix and replete with vague, immaterial, and evidentiary allegations, or which contains involved and repetitious verbiage, violates the rule. Such complaints place an unjustifiable burden on the defendant to determine the nature of the claim and speculate on defenses, and the court to sort out the facts. Nevertheless, the defendant is not required to forego raising a defense through factual allegations to state contentions in a short and concise form, because the proper length of a pleading depends upon the case, the type of case involved. So, we see here the observation: each individual count of a complaint, rather than the entire complaint, should be tested for simplicity and brevity under the requirements of the rules. So this is a nice little design review for when you're writing complaints or pleadings, is that rather than the entire complaint, each section should be tested, right? Each individual count should be tested for simplicity and brevity under the requirements of the rule, the prolix rule. Objections to non-conforming complaints. Generally, objections to a complaint on the ground that it does not conform to the rule should be presented by, first, a motion to strike the objectionable provisions, and then a motion for a more definite statement, rather than by a motion to strike entire complaint or a motion to dismiss. So, if it doesn't conform to the rule, the prolix complaints, things like that, it should be done in 2 steps. Motion to strike, then a motion for a more definite statement. Let's move along. And if anyone's just arrived here, see if this is working here.
The crime says, hit the like.
All right. So here we go, the appendix of federal forms. This is the one that I have a little trouble finding these days, but I did locate one. We're going to be looking at it in a second. Yes, the forms contained in the appendix of forms in the Federal Rules of Civil Procedure are sufficient under the rules and are intended to indicate the simplicity and brevity of statement which the rules contemplate. Practice tip: when properly used, the forms may be relied upon as being invulnerable to attack under the rules. Now that's powerful, invulnerable to attack. I think it'd be worthy looking at these forms. I wonder why they removed them. Use of the forms is not mandatory, of course. And then we're on to paragraphs. So that was a little teaser, but we're going to be coming back to that federal forms there. Numbered paragraphs. The allegations of a pleading should be presented in separately numbered paragraphs. Whether a pleading conforms to this requirement is a matter within the discretion of the court, whose decision on this matter is not a ground for reversal on appeal. Oh, wow. In some jurisdictions, the opponent must, by motion, raise an objection to the pleading for its failure to comply with this requirement. In some cases, specifying which portions of the pleading are in violation of the rule. Here's our practice tip. Some jurisdictions require that when more than one cause of action is alleged in a pleading, each should be alleged in a separately numbered paragraph. We saw before that you need to check each allegation or each count within its the rules of brevity and simplicity and clarity. And here again, it's important to keep that there's more one cause of action alleged also. They should be alleged in separately numbered paragraphs. So everything being evenly or being spaced appropriately aids the court in sifting out what facts need to be used and which chain of reasoning applies. So the numbered paragraph example for the first allegation was supporting facts, 2, second allegation was supporting facts, and 3, the third allegation was supporting facts. So that's a pretty good, straightforward numbering example. A little too rudimentary for me, but let's move along. Here's our federal rules requirement for federal practice. The rule requirements. A party must state its claims or defenses in numbered paragraphs, each limited as far as practicable to a single set of circumstances. A later pleading may refer by number to a paragraph in an earlier pleading. If doing so would promote clarity, each claim founded on a separate transaction or occurrence and each defense other than a denial must be stated in a separate count or defense. Now, the purpose and application here is this provision is to require clarity in pleading and to facilitate responsive pleading by enabling the defendant to admit or deny each fact or set of circumstances separately, paragraph by paragraph. Separately numbered paragraphs may be desirable or even essential when separate counts are not required by the rule, as when the plaintiff's claim is based on alternative legal theories. So they're not separate counts, they're alternative legal theories. So even still, you keep them numbered. It enhances the clarity for the court, it facilitates precise responses, and it supports organized case management. All good points for efficiency, one of the other goals of the rules. And on to compelling proper formatting, the responding party options. A responding party may be able to compel separate paragraphing and numbering of a complaint. All right, indeed. Thank you for, the chat doesn't read the icons. I might be able to get it to do that in the future. Responding party options. So here's some of the things they can compel. A motion for a more definite statement, a motion for an order requiring the plaintiff to state the avertments in separate paragraphs. Wow. The court may deny a motion for a more definite statement, but nonetheless require a plaintiff to amend the complaint to comply with the rule. So again, 119 pages. But again, if it's not numbered properly, the opposing party can do a motion for a more definite statement. And the court would order a motion requiring the plaintiff to state the averments in separate paragraphs. It's the court's discretion, though, because when a complaint contains only a small number of paragraphs, the plaintiff's failure to number them cannot be said to prejudice the defendant, and a court is unlikely to order the plaintiff to separately number the paragraphs, like the 1, 2, 3 example we saw. Similarly, a court is unlikely to strike a pleading because it is not in the form of numbered paragraphs when it is sufficiently clear to enable the defendant to respond. So, practice tip. Dismissal is not an appropriate remedy for the mere technical violation of the rule's formatting requirements. Indeed. Let's move along here. And we're on to our conclusion here. Draft pleadings for the reader. Oh, see, the intent here is great. Clarity, conciseness, and good faith are the cornerstones of effective advocacy. Number one, prioritize substance. Focus on clear facts over technical form, but use form to enhance clarity. Embrace brevity. A concise, direct statement.
Cab driver says, Golden Nuggets, thanks.
Yes, indeed, these are. And it's all courtesy of American jurisprudence. So we want to embrace brevity. A concise, direct statement is more powerful and effective than a prolix narrative. So you don't want a story of a lot of words. As they say, less is more. Structure for understanding. Use captions and numbered paragraphs to guide the court and opposing counsel. And of course, maintain integrity.
Bill Simmons 4426 says, prolix and sham are fun words.
Yes, indeed. Prolix is great to use, conversationally these days. That's what it mostly is. But in the old days, that was something you could say when someone started to ramble on. Okay, so of course we want to maintain integrity through the pleadings. The system is designed to penalize sham and frivolous claims. Plead honestly. Effective pleading is not about winning on a technicality. It's about clearly and fairly presenting the basis for justice. Well said. From that, I want to take us on to the special treat we have here regarding the forbidden appendix of forms. So I was able to dig this up. This is, I think they ended this around 2015. Nonetheless, let's start to look at some of these here real quick, and then we'll be done for those that stay to the end. So we have here appendix of form. Here's an introductory statement. The following forms are intended for illustration only. They are limited in number. No attempt is made to furnish a manual of forms. Each form assumes the action to be brought in the Southern District of New York. If the district in which an action is brought has divisions, the division should be indicated in the caption. Except where otherwise indicated in the pleading, the motion, the other paper should have a caption similar to that of the summons, with a designation in the particular paper for the word summons in the caption. Okay, Form 3, the words allegation of jurisdiction are used to indicate the appropriate allegation. Form 2. And each pleading motion and other papers to be signed in his individual name by at least one attorney of record. The attorney's name is to be followed by the address. Okay, if the party is not represented, the signature and address of the party are required in the space of those of the attorney. So let's read on here. Here's one here: United States District Court, AB plaintiff versus CD defendant, civil action or file number. And we have here, this is a summons, and they get the little bracket there. To the above named defendant, you are hereby summoned and required to serve upon the plaintiff's attorney, whose address is this, in answer to the complaint, which is herewith served upon you, 20 whatever days of this summons upon you. Well, a lot of redundancy there. Exclusive of the day of service. If you fail to do so, judgment by default will be taken against you for the relief demanded in the complaint. Wow, that's heavy. This summons is issued pursuant to Rule 4, Federal Rules of Civil Procedure. So we get all this good stuff here. Then we have the notes of Advisory Committee on Rules 1948 Amendment. So change nomenclature to conform here. Notice a lawsuit requests a waiver of service of summons. Wow, so this is another one here. To A as B of C. Ooh. Let's see, we have some other ones here. Notes. Here's a waiver of service of summons. Duty to avoid unnecessary cost of service of summons. Allegation of jurisdiction. Here's that Form 2 they're talking about. Jurisdiction found in the existence of a federal question. This is key. Jurisdiction found in the existence of a question arising under particular statutes. Jurisdiction found on the admiralty or maritime character of the claim. Wow. This case of admiralty and maritime jurisdiction, as hereinafter more fully appears, if the pleader wishes to invoke the distinctively maritime procedures in Rule 9H, add the following of its substantial equivalent. This is an admiralty or maritime claim within the meaning of Rule 9H. So we have some explanatory notes.
Division Hippie 1776 says nice.
Yeah, this is, you can see why they removed this. Get a copy while it's still available in the archives. I searched just for, what was it? It was Federal Rules of Civil Procedure, Appendix of Forms. All right, so I think 2015 was the last date, or 14, somewhere around there. Diversity of citizenship, USC Title 28, diversity of Section 1332, diversity of citizenship, amount and controversy, costs, as amended. Let's see, says, for the purpose of this section, a corporation shall be deemed a citizen of the state by which it has been incorporated and of the state where it has its principal place of business. Thus, if the defendant corporation in Form 2A has its principal place of business in Connecticut, diversity of citizenship would not exist. An allegation regarding the principal place of business of each corporate party must be made in the jurisdiction to an allegation regarding its place of incorporation. Wow. Jurisdictional amount, pleading venue. Since improper venue is a matter of defense, it is not necessary for plaintiff to include allegations showing the venue to be proper. That's a matter of defense. Wow. Interesting stuff here. Notes of advisory committee. Oh, geez. Here's a complaint on a promissory note. Interesting form here, huh? Allegation of jurisdiction. Ooh, defendant on or about this day, 1935, executed and delivered to plaintiff a promissory note. Wow. Copy of which here is promised the sum. Defendant owes to the plaintiff the amount of said note and interest. Whereas the plaintiff demands judgment against, wow, this is interesting. The pleader may use material in one of these three sets of brackets. He will choose upon whether he desires to plead the document verbatim or by exhibit or according to its legal effect. Wow. Then we go here, damages, complaint on account, complaint for goods sold and delivered, complaint for money lent, complaint for money paid by mistake, complaint for money had and received, complaint for negligence. Here's your negligence one we were going over previously here. Allegation of jurisdiction. On June this, a public highway called Boylston Street in Boston, Massachusetts, defendant negligently drove a motor vehicle against plaintiff, who was then crossing said highway. As a result, plaintiff was thrown down, had his leg broken, and was otherwise injured. Was prevented from transacting his business, obviously, suffered great pain of body and mind, I would imagine, and incurred expenses for medical attention and hospitalization in the sum of $1,000. That's June 1936. Wherefore, plaintiff demands judgment against the defendant in sum of this. So, contributory negligence is an affirmative case. The complaint need contain no allegation of due care of plaintiff. Interesting stuff here, and it kind of ties into the tort we were looking at earlier too. Complaint for negligence, where plaintiff is unable to determine definitively whether the person responsible is C, D, or EF, or whether both are responsible, and where his evidence may justify finding willfulness, or of recklessness, or of negligence. See, we're getting right to the tort stuff again. Allegation of jurisdiction. Here's Boylston. This is the same thing. Drove as a result, was thrown down, had his leg broken. Demands judgment. So, interesting here. Complaint for conversion. Wow, defendant converted his or her own 10 bonds of the company. Ah, wow, conversion. Specific performance to contract to convey land. So, wow. Oh, complaint on claim for debt to set aside fraudulent conveyance under Rule 18B. Allegation jurisdiction, then defendant CD on or about this date executed and delivered to plaintiff a promissory note in the following words, figure which is Exhibit A, whereby defendant CD promised to pay plaintiff the sum. Defendant CD owes plaintiff the said note, amount of said note. Defendant CD on or about that date conveyed all his property to describe, okay, so the fraudulent conveyance, wow. Complaint for negligence under Federal Employers Liability Act. Complaint for damages under Merchant Marine Act. Complaint for infringement of patent. Complaint for infringement of copyright, unfair competition. We're just going to read these titles here because it's a little bit longer than I thought. Complaint for interpleader and declaratory relief. But just to let everyone know what wealth of great forms are here just to go over. And the amazing thing is, in today's day and age, you can just pump these things into some of the large language models and really have it use it as its own framework for writing your own pleadings. So this could be actually a really good resource here. And again, these are essentially immune to any kind of attack on violating any of their rules because these are structured specifically to conform to the rules. So the closer you stay to these forms, so to speak, the more less likely to be attacked as far as being compliant with the rules. The answer is compliant. Here we go. You can have forms who say you're compliant with the forms. Summons and complaint against a third-party defendant. Wow. Well, we're missing this one here. Huh. But we could probably get that. I'll have to find this. Nice. So we got some imagery we don't get there, huh? I'll find that somewhere. Well, I guess that's everyone's homework is to find this document and make sure you get these little broken images. It might be in the source document. It's just not rendering here in the stream. Nonetheless, you can see here we get a wealth of information here. Judgment on decision by the court. Notice of available magistrate judge to exercise jurisdiction. Consent to exercise of jurisdiction by a United States magistrate judge. Order reference. Interesting. Yeah, so a lot of neat stuff in here. And that takes us to the end here. This is the last one here is the order, the report of parties planning meeting. Interesting here with a meeting. All right, so we had a nice little diversion here. I hope everyone stayed for the end. That was a nice treat. Again, this is you can find this online. That's the Federal Rules of Civil Procedure Appendix of Forms. It's been I don't know if you say deprecated or eliminated. It's been totally taken out from the Federal Rules of Civil Procedure. However, I'm sure some of the rules or the laws or whatever they apply to have changed over time, and maybe some of them have been superseded. However, it still gives you a good idea of the general form of constructing the pleadings. And again, using them as a guide.
J494 says, thanks again for another awesome live. The tribe.
Hi, greeting. Yes, you're welcome. And live, as it says there. Wonder why I didn't get the word right, but yes, you're very welcome. I'm sure everyone's going to find...
Bill Thimmeth 4426 says, thanks for the treat. Take care all.
Indeed, it was a treat and not a trick. So with that said, I'd like to thank you all for coming. If you want for further research, look at that Federal Rules of Civil Procedure Appendix of Forms, and it has to be an archive version because it's no longer on the official government archives or the government site, the GPO site. So search out, Google's your friend on that one. You will be able to find it. I was able to find it rather quickly, and I guess you'll find those images that were missing from this presentation as an extra bonus. With that said, salute to you all for being here, and I'll see you on the next one. Peace out.
The tribe says, hit the like.